Welcome to today's webinar hosted by the Current Consulting Group and sponsored by GAZE. I'm Jessica Polk with the Current Consulting Group, and I'll be conducting today's presentation entitled Identifying Impairment and the Evolution of Drug Testing Technology. We'd like to welcome you all to this presentation. We'd like to thank our sponsor, GAZE. Today's webinar is sponsored by GAZE, and if you're struggling with employees using cannabis in legal states or with employees using legal drugs like Delta H THC, you need to know about this. GAZE uses highly accurate eye tracking technology to detect current impairment from virtually any class of drug. In just 6 minutes, you'll have a clear report indicating whether an employee is showing signs of impairment so you can make the right decision in the moment. For TPAs, you can use GAZE as a new service for your customers to help them identify current impairment rather than just prior drug use. Their solution is in use today by TPAs and businesses from less than 50 employees to all the way up to Fortune 500. It's 50 state legal and it truly feels like the future of workplace safety. We'd like to thank them for being part of today's webinar. Today's presentation also qualifies for continuing education credits from SHRM, CCDAP, and from HRCI for those who attend today's presentation in its entirety. With us today on our presentation are Bill Current from the Current Consulting Group and Ken Fickler from GAZE. Ken is the founder and CEO of GAZE, a first-of-its-kind real-time impairment detection platform. GAZE analyzes eye movement changes using artificial intelligence to discover impairment from cannabis and other drugs. And Bill Current is the founder and president of Current Consulting Group, which he founded in 1998, and it has become the #1 recognized brand name in compliance, business development, and marketing consulting in the drug testing industry. And so with that, we're going to go ahead and turn the microphone over to Bill to get us started on the content of this webinar.
All right. Thank you very much, Jessica. Welcome everyone to today's presentation. I just want to go back one slide here to the slide about GAZE and their contact information. So one of the things we do at the Current Consulting Group, and many of you in the industry will know this, we monitor trends and anything to do with employee screening. We monitor trends and developments in our industry, including new and emerging technologies. And one of the things that we're convinced of, and this goes back to, and I'll discuss this in more detail during the presentation, but the legalization of marijuana is really forcing a lot of employers to choose between drug testing or not drug testing, especially when it comes to marijuana, or maybe it's pre-employment screening, etc. But the fact remains that substance abuse is on the rise, and employers still need tools and instruments to help the techniques to help them determine whether somebody's impaired on the job. And that's what I love about this GAZE technology. Ken will go into a lot more detail about it later, but I think there's a place for the combination of drug testing, especially new technologies in drug testing, with impairment screening like you're going to learn about today with the GAZE technology. So thank you, Ken, for sponsoring today's presentation. We're going to talk about impairment in detail, the difference between impairment and under the influence. I know a lot of people think they're one and the same. Those two words and terms get used interchangeably, but they are different. We'll review some state laws and how they're starting to really delve more into impairment identification as opposed to drug detection or drug use detection. And then we'll talk about the GAZE technology. I think you'll find that fascinating. And then we'll wrap up with sort of a combination of how to get the best of both worlds when it comes to drug testing and impairment screening. So first, let's talk about the difference between being under the influence and being impaired from a practical standpoint. And as I launch into that, please feel free to submit your questions. Any questions you have about drug testing, about impairment screening, or new technologies, etc., we're happy to address those for you. So first, let's start out with what is impairment. So the National Safety Council defines impairment as this way. So, quote, the inability to function normally or safely from a change in behavior resulting from, and then they list 4 different categories: chemical substances like alcohol, opioids, cannabis, physical factors like fatigue, social factors, professional and other stressors, so that's stress and anxiety, and mental health well-being, illnesses and other factors that may affect a person's ability to function normally within the scope of their employment. Now look at the second column over there. So typically, okay, and I use that word typically because, as I mentioned, under the influence and impairment sometimes get used interchangeably. I don't think they're the same thing, and I'm going to explain why here in a second. But typically, impairment is a legal term. There's a set, generally accepted standard for what is impairment. For example, a blood alcohol content level of 0.08 or higher on the highway, on the road, would legally make somebody impaired, driving while impaired, or driving well impaired from something, right? In this case, alcohol with the 0.08. But it's a diminishment or loss of function or ability. So impairment can impact cognition, the ability to think clearly. It can cause memory problems, which is important when it comes to in remembering instructions, for example, that you may have received in the workplace, or being able to follow instructions or follow common procedures in the workplace. And it also could result in some type of psychomotor problems. So the ability to think clearly and then act physically upon that, to understand that you're getting too close to the driver in front of you, but then also have the psychomotor skills to be able to apply the brakes. And so that all kind of factors into what is impairment and how does it look. So it can be caused by lots of different things, right? So we're not just talking about substance abuse, although that's a big factor, of course, but it could be sleep deprivation. Maybe you've got a newborn baby in the house and mom and dad are both not getting a full night's sleep, and one of them shows up to work the next day without having had a full night's sleep. It could be stress or anxiety caused by circumstances taking place in a person's life, and there's no substance abuse, no alcohol use or anything of that nature that's involved. It could be an illness, of course, it could be drugs and it could be alcohol, but there are lots of different things that can impair someone's ability to function normally, okay? And there's lots of common signs. We won't go through all of these, but these are the things that we would look for, or as an employer, these are the things that we might train our supervisors and managers to be aware of or to be able to notice in terms of determining whether or not somebody could possibly be impaired on the job. Lots of times with supervisors and managers, what we're asking them to do is to monitor job performance. Can people get the job done, the job that we've hired them to do? It's not necessarily asking these managers and supervisors to be like substance abuse counselors or treatment advisors or anything of that nature. We're asking them to judge job performance. Sometimes some of the factors that you see on the screen here are things that affect job performance, and the outward appearance of like watery or red eyes or slurred speech, things of that nature, may indicate that somebody's been using drugs, but beyond that, it's indicating that somebody may be impaired or under the influence. I'm going to talk about that here in a second. Now, there was a study done recently, and we don't have the source on this slide, but if you'd like to know where this came from, I've got that in a document that I wrote on impairment. So, but it was a study done, a survey done of employers on the subject of impairment. The first slide and the last slide are really critical to the points that are being made here. 33% of employers recognize that impairment is impacting their organization in terms of safety, employee retention, productivity, finances, and the overall reputation of the company. Now look at the last bullet. However, 13% of employers who were surveyed said that they don't consider impairment an important consideration when determining someone's fitness for duty. 77% view impairment as an important consideration, but 13% do not. I'm not sure how you can get to that point where in your mind you're thinking somebody being impaired on the job is not necessarily an important consideration for fitness for duty. I think it has everything to do with that. But it's interesting that there is a percentage of employers who don't make that connection. Now, what is under the influence, right? Impairment, sort of a legal definition, but under the influence can sometimes be referred to as a policy definition, okay? It's a standard established by the company and defined in the company's drug-free workplace or drug testing policy. Now, if we're talking about substance abuse, under the influence, we're talking about, well, let me rephrase it. If we're talking about under the influence, we're talking about people that are using drugs, right? They're under the influence, whereas impaired could be impaired by lots of different things other than substance abuse. But in your policy, you define what under the influence means, and it's very important that you do this. I'll explain why in the next slide, is that you define it as the signs and symptoms, like we talked about on the previous slide, a positive drug test or alcohol test result, excuse me, could be part of the definition of under the influence. In other words, if somebody tests positive for marijuana, then by company policy, they're under the influence. We're not saying that they're impaired. We're not saying they're a drug abuser or a drug addict. We are just saying that they're under the influence because they tested positive or they're showing some type of outward signs or symptoms of being under the influence, or a combination of all of those things. Now, keep that in mind as we look at the difference between the two. So let's say, for example, an individual has one drink and they're not necessarily impaired after having one drink, right? But depending on what your blood alcohol content cutoff level is for determining whether somebody has violated the company policy in terms of alcohol consumption, they could possibly be, by company definition, under the influence. Now look at the last, the two bullets there. Look at the second one. Impairment occurs when you can no longer function at a normal level. That's going to vary from person to person, right? But that impairment or the fitness to do the job that you've hired that individual to do is the key factor with impairment, right? But under the influence is somebody having drugs or alcohol in their system during the workday in violation of the company. For example, if the company has a zero tolerance policy for alcohol consumption during the workday, whether it's during someone's lunch break or on some other kind of break from work, and they test positive, regardless of what prompted the test in the first place, maybe it was some type of aberrant behavior, but if they test positive, depending on how you've worded your policy, what you say in the policy, that would be a violation of the policy. They would be considered under the influence, whereas impairment is going to be more of a, are they able to do their job? Now, in a safety sensitive work environment, you're probably going to lean more heavily towards how you define under the influence, right? Because we don't want to take chances with somebody who's driving a delivery van or who's operating a forklift, etc. Can a drug test determine? This is so critical, right? Hopefully you've never heard somebody say that a drug test proves impairment, because it doesn't. It's just not possible from a legal or a scientific standpoint to say that somebody who tests positive is absolutely impaired, because the drug test doesn't prove impairment. It just proves that somebody has drugs in their system. So if, again, you've defined as part of the definition of under the influence, if you've defined the term as, among other things, a positive drug test result, it's a violation of the company policy. Now, conversely, even though a drug test doesn't prove that somebody's impaired, a negative test doesn't necessarily mean they're not impaired, right? So other factors come into play. What triggered the drug test in the first place? And that's all part of what's written into your drug testing policy. And it's important to understand these things because, among other things, right, we understand that impairment can be caused by lots of different factors, right, besides substance abuse. And accusing someone of being impaired on the job doesn't necessarily mean that they've been using drugs recently enough to trigger a positive drug test result, okay? So now look at the third bullet down. Proving someone's under the influence is more cut and dry. A positive drug test result, depending again on how you've defined the term under the influence in your policy, in conjunction with a positive, with some other type of behavior that you've been documenting as you look at the very last bullet at the bottom there. All of this combines to give the employer the ability to do something about the issue, it can be considered a violation of the company policy, but also could trigger, I'm not suggesting this, but it could trigger, depending on how your policy is written, it could trigger adverse employment action. And in that case, the employer's position is a stronger position from a legal standpoint because it's in the policy. We've defined it this way. We're not accusing anybody of being a drug user or a drug abuser or an alcoholic or anything of that nature. We're just concerned about fitness for duty, whether the individual can do the job. And we define under the influence as somebody who has a positive drug test result. Now, and there would be other things as well, okay? So throughout this presentation, we'd like to pause in a few different places to ask you to participate in a poll. So I'm gonna bring Jessica back in to do our first survey.
Thank you so much, Bill. All right, our first question, our first poll for today is, do you understand the distinction between impairment and under the influence in a policy? So I'll go ahead and launch that poll for us. And if you would be so kind as to participate, yes, I understand the distinction. No, I do not understand the distinction, or I have not considered this before. There's no wrong answer. We just want to kind of get a feeling for where you all are at. And so we'll just give you a few more seconds to participate.
Well, you know, Jessica, we probably should have included a fourth option, which is I think Bill's off his rocker on this one, but we'll just go with have not considered this before, and then I'll know what.
Yeah, that's actually what that meant. That's kind of like it's hidden in there. It's reading with lines, right? Yeah. Awesome. Okay, it looks like we are slowing down in our participation, so I'll go ahead and I will close this poll, and I'm going to share the results with everyone. And it looks like 75% said they understand the distinction. So you're pretty safe here, Bill. 8% said, no, I do not understand the distinction, and 17% think you're off your rocker. I mean, have not considered this before. Thanks so much. I'll go ahead and hide this poll and turn it back over to you, Bill.
Okay. So as we continue with the presentation, I would have expected, not that do you think I'm off my rocker or anything like that, but that maybe the haven't considered it before might be 17% or even higher than that in some instances, because this is something that employers don't always understand because your state lawmakers who write your drug testing laws don't understand it as well. You'll often see in a state drug testing law language that confuses impairment and under the influence or uses them interchangeably even in the same statute. And that contributes to the confusion that employers have. It's not really their fault because we, for many years, treated it as those two terms as one thing that's interchangeable. It's not. Now, we've kind of covered this territory here. I want to bring Ken in for this next slide, my co-presenter. Ken, tell us a little bit about how you put this together. And I know there's lots of different sources for window of detection. Window of detection is how long a substance or various substances are detectable in different types of drug testing methods. And so maybe Ken, you can walk us through this and show us how GAZE compares to drug testing technologies.
Yeah, thanks so much, Bill. Really appreciate the webinar so far. It's great content. So basically what this chart is intended to show is the window of detection for each of the most common tests for smoked marijuana. And the intent here is to demonstrate that impairment detection technology, which is a category of technology that GAZE falls within, is really detecting impairment as it is being experienced. And so it is only able to detect impairment as it's being experienced and cannot detect signs of impairment beyond that window of acute peak impairment. This is really important because what a lot of businesses have decided that they care about is whether or not someone is actively impaired on cannabis while they're at the place of work rather than what they did over the weekend. So this really matters if, for example, you do a drug test on a Monday and someone consumed cannabis on Sunday night, they could easily and most likely would be positive on each of these other tests with the possible exception of breath. So I'll really quickly run through these. As I said, impairment detection technology is really the only one that is detecting impairment as it is being experienced. There's significant overlap with breath, of course. So breath is detecting the usage of delta-9 THC for about 3 to 4 hours since it was last consumed. And that can be an interesting point of data for companies, but doesn't always indicate that someone is actively experiencing impairment. There's been some recent articles that are recent studies that are very controversial that are showing that people who are consuming medical cannabis actually are not showing signs of impairment if they consume the dose that they were prescribed. And so there's lots of conversation happening about this. I won't get into that controversy here, but just know that there is a lot of controversy about whether or not someone is necessarily impaired if they've consumed cannabis recently. So the breath is, of course, the most sensitive to recent use, and then next up is oral fluid. This is saliva test, and studies have shown that people are commonly, and manufacturers say in their manuals that people are able to be positive on a THC oral fluid test for up to 48 hours since they last used. Actual field use, I think, varies a little bit. It's I think pretty uncommon for people to actually be positive for up to 48 hours, but it does happen, and that's something that people should keep in mind. Blood tests, this is mostly a law enforcement test, or in the case where there was an accident or something like that, where you need a really good forensic type result. Up to a week, typically, that's again, just a little bit shorter is what is seen in the field as far as we understand. Urine, commonly a couple weeks, up to 6 weeks in some cases. And hair test, of course, is the longest at up to about 4 months since the person last used cannabis. Bill, anything to add to that explanation?
Yeah, I think a couple of points. One, if you're talking about oral fluid and urine testing, the window of detection could vary depending on whether it's a lab-based test or an instant result test, what the cutoff levels are, because they can be quite different when it comes to, especially with testing for cannabis, and so those factors come into play as well. With oral fluid testing, like Ken explained, the drugs become detectable in a person's oral fluid sample within just a handful of minutes, say 10 to 15 minutes after usage, and that's because you're detecting the parent drug, as Ken pointed out, the psychoactive component of marijuana, tetrahydrocannabinol. With urine testing, you're going to have a lag time of, say, 6 to 7 hours before a drug becomes detectable in a urine sample, because you're detecting a metabolite of the drug. And I'll get into that a little bit in a second, because I'm going to talk a little bit about these new laws in California and Washington, and that's a big factor in those two states now. Anything else, Ken, on that?
No, I don't think so. I'll get into how our technology works and why it's important a little bit later.
Okay, so I want to go back to this previous slide. Again, the window of impairment is the period of time in which somebody has some kind of diminished cognitive or psychomotor skills or abilities during that time. And when it comes to drug use, it could be influenced by lots of different things, whether somebody's impaired or has these diminished cognitive or psychomotor abilities. It could be the individual's drug use history, how often they use the drug, the level of THC. You often hear about the potency level of THC, excuse me, in the cannabis that somebody's using. In Colorado, for example, there have been reports that indicate that the potency level of the cannabis that's sold in many places in Colorado is above 80%. That's extremely on the sort of the fringe of measuring THC potency. Normally it's much lower than that, but it can be higher. And there's a lot of, now that it's legal in so many states, there are efforts to sort of create very potent versions of THC. And then how the drug is used, whether it's consumed with a with a marijuana laced brownie versus somebody who's smoking joints, etc. And then also the task that you're asking somebody to perform. That can determine whether or not somebody's quote unquote impaired in terms of what you're specifically asking them to do. And so when you look at Ken's chart here on the window of detection, being able to detect drugs in someone's system, depending on the drug testing method or the impairment screening method that you're using, would possibly have an impact on, or would be impacted by, the type of drug that they use, when they used it, how much of it they used, etc. This particular chart, which I think is excellent, is marijuana based, but you can find charts like this, and we have them as well for other drugs. So let's pause again and take another poll question. Jessica, why don't you walk us through this?
Happy to help. All right, here we go. This poll is asking, have you ever had to discipline or terminate an employee who failed a drug test, even if you weren't sure they were impaired? And so it's just a yes or no. I'll go ahead and launch that for us. Again, we're not sharing who you are with your responses, so you can go ahead and participate without feeling any judgment. And it looks like we're slowing down, so I'll close this and share the results. And with our participants today, we have 45% saying yes and 55% saying no. And I'll go ahead and hide this and turn it back over.
Okay, and that's a very interesting response, because obviously, as we pointed out, I'm going to talk about it on the next slide as well, we're not suggesting that a drug test proves somebody's impaired. And so a drug test result may be a violation of the company policy because of the way you define under the influence, but you're not necessarily accusing somebody of being impaired, and you may not even suspect or believe that they're impaired. But again, it comes back to what your drug testing policy says. So again, we're not saying that a drug test measures impairment or indicates impairment, etc. But especially in this age of legal marijuana, I think it's important to point out a few key factors here. A positive marijuana test on its own should not be the sole basis for workplace discipline in states that require proof of impairment. So there are a number of states that have legalized marijuana either for recreational use or medicinal use. And you see this a lot in the medical marijuana laws around the country, where an individual may test positive, for having marijuana in their system, but the positive drug test result itself on its own is not sufficient justification for adverse employment action in some states. And so you would need other things like a impairment screen to go along with it, like what GAZE is able to do, or some other paper trail of documented violations of the company policy, showing up late on a regular basis, getting in altercations with coworkers or supervisors, etc. And all of these things together, combined, give the employer the option of meting out some type of adverse employment action. And it's got to be in your policy. It's got to be part of the written policy of the company, so that if anybody comes back and challenges that at any point, you come back and you say, this is what's in our policy, this is how we do it every time, and this is the proof that we have shared this information with the employee in question. They signed the form saying that they had received the training, etc. So always a good idea to do that. Now, I'm going to breeze through a couple of slides here because I want to make sure we spend plenty of time on some slides that Ken has coming up. But it's important to know that the legalization of marijuana coincides with another trend that is very disturbing, which is, according to Quest Diagnostics, which puts out a great report every year called the Drug Testing Index, post-accident positivity for marijuana in 2023 was at a 25-year high. So we're seeing a dramatic increase in post-accident positive drug test results for marijuana that coincides directly with the last 10 to 12 years of the legalization of marijuana really spreading quickly and from state to state all across the country. And so this is important to understand, that if you're in a situation where you're wondering whether we should test for marijuana, whether people at work under the influence, possibly impaired by marijuana use, whether or not you have the right, or even if it's worth drug testing for marijuana, I think that on the surface, it may seem like a good idea to let's just get rid of this, it's too complicated, but it could very well lead to more problems with you know, again, we're not saying the drug test proves impairment, but with more employees being impaired on the job because of a company's very lax policies when it comes to marijuana use. There was a study that came out in 2021 from the University of Sydney that looked at 80 different studies on the subject of marijuana and impairment. And they came to the conclusion that the average window of impairment for cannabis is 3 to 10 hours. And that can vary by a lot of different factors. You see it there in that sub-bullet and just below the first bullet. But we've talked about this on other slides as well, right? But it's a major issue right now because so many states have legalized marijuana and many employers are sort of wishy-washy when it comes to whether or not their drug testing program should continue to include marijuana. Do we have the right to do this? And I think a lot of it comes down to what type of drug testing method do you use? Now, there are certain drug testing methods that are more apt at detecting recent use. I mentioned oral fluid because it detects the parent drug or parent THC. That becomes detectable in an oral fluid sample within about 10 to 15 minutes after usage. Whereas with urine, you're waiting for the drug to be metabolized in the person's system, so it doesn't become, the metabolite of cannabis doesn't become detectable in a urine sample for about 6 to 7 hours. The individual may still be on the job and impaired by the marijuana use, but your drug test result from urine isn't even going to start to detect marijuana in that person's system for 6 to 7 hours. Whereas with oral fluid or possibly with breath, although breath is just for THC, so you're not testing for the other drugs, but that could possibly also show very recent drug use. And I think that's going to become a very, very important consideration and priority for employers, especially in these states that have legalized marijuana and have included language in their marijuana laws that really sort of leans toward protecting the rights of the marijuana user. Now, these next two slides are just a couple of examples of some very, very tragic accidents that occurred where people lost their lives, and it turned out that it involved drug abuse in the workplace. I'm not going to go into all the details on this one, but it's there. You're going to get these slides as part of the recording. There was an incident, though, in Albuquerque, New Mexico. You might consider this more like a small business situation, right? This was a hot air balloon that crashed into a power line. The basket detached from the envelope and plummeted to the ground. 5 people were killed, including the pilot of the hot air balloon. And a NTSB evaluation or investigation, I should say, was performed afterwards, and they came to the conclusion that the accident was in part caused by the pilot's use of cocaine and cannabis. So that pilot had cocaine and cannabis in his system the day that he launched that hot air balloon. And the NTSB said that contributing to the accident was the pilot's use of impairing illicit drugs. Some impairing effects of THC would likely have been present that would have affected the pilot's abilities to successfully operate the balloon. And so, of course, we don't want to highlight this, you know, for sort of just dramatic effect. The problem is, or I should say the truth of the matter is, that sometimes impairment on the job from drug use can have some very devastating consequences. And of course, some people lost their lives here, and we don't want to make light of that in any way. But again, the employer has to be responsible to make sure that all of his or her workers are fit for duty when they start their jobs, and they remain so throughout their shift. Now, we've got another poll question, Jessica.
All right, here we go. This is our last poll, I believe, as well. So, are you aware that common drugs of abuse like fentanyl and Delta-8 THC are not included in standard drug tests? Launching the participation. Yes, I'm aware of this. No, I was not aware of this. I have not considered this. We do appreciate your participation in these polls. This is enriching for all of us. So it looks like we're slowing down in participation. I'll go ahead and close this poll and share the results. So we have 85% yes, I am aware of this, 12% no, and 2% I have not considered this before.
Okay. Well, this is an interesting poll question because we, at the Current Consulting Group, we do a survey of the drug testing industry every year in the first half of the year, and then in the second half of the year, we do an employer drug testing practices survey. And last year during the employer survey, we asked the question, do you test for fentanyl? And many people said that they thought they did, but the reality was fentanyl is not normally included in a drug test panel. And so even though it's a very, popular substance of abuse right now and growing in usage, most employers really aren't even testing for it. And so it may be something you want to consider, and you want to talk to your drug testing provider or your lab about that. Now we're going to move on to state law issues here as we sort of merge into a more specific discussion of impairment, impairment screening, I should say. And I'm not going to spend a lot of time on this, but I can circle back if you have questions about it. But I think most of you are probably aware that both California and Washington passed laws in the past that became effective January 1st of this year that essentially prohibit employers from discriminating against employees and in California and employees in California and employees and job applicants in California and Washington, discriminating against them for their legal use of marijuana away from the workplace, not during work hours. And essentially what the laws say in a nutshell is that employers cannot take action based on a positive drug test result that shows the presence of the quote unquote non-psychoactive metabolite of cannabis. Okay, that's very interesting language, because I think what they intended to do from the press clippings I read after the California law passed about a year and a half ago, I think what they intended to do was to stop all drug testing for marijuana. They didn't do that though, because of the way they worded the law. The non-psychoactive metabolite means that in California and Washington only applies to pre-employment screening, you couldn't use urine testing and take any action based on that urine test, because urine reveals, or within urine testing, it reveals the presence of the metabolite of cannabis, as opposed to the parent drug or parent THC, which is what is detectable in an oral fluid sample. And so I've got some great slides in here about California and Washington. I'll leave it to you to go through these in greater detail. A lot of good information. We also have an article that we wrote on this, so if you're interested in that, just email Jessica afterwards. We have a general email box that you can use. If you'd like to get a copy of that, we'll send it out to you, okay? I do want to point out this one big issue here, which is some people think the California law and the New York law, when it comes to testing for marijuana, are the same thing, or they're very similar, based on the same thing. They're actually very different. New York is really the only state that prohibits employers from testing employees and applicants for marijuana. Now, there are exceptions in New York, okay? And there are exceptions in California. In fact, interestingly enough, the entire construction industry has a safety sensitive carve out in the California law, meaning employers in the construction trades can still test with urine and take action based on a positive test for marijuana. In New York, and of course, the DOT regulations are not affected by this. If you're a DOT covered employer in California or Washington or New York, then you not only can, but you must test for marijuana. And if somebody tests positive, then those various factors in 49 CFR Part 40 and in those specific DOT mode laws go into effect, okay? But I wanted to make the distinction that California and New York are very, very different. In fact, the New York prohibitions are actually a result of the New York Department of Labor coming out with guidance on marijuana. It's not even a statutory thing in New York, whereas in California and in Washington it is. And in the Washington law, and also in the California law, but worded somewhat differently, there's this language, if you look at that second bullet down, again, the Washington law, SB 5123, only applies to pre-employment testing, but it says that hiring decisions can be based on scientifically valid drug screening conducted through methods that do not screen for non-psychoactive cannabis metabolites, which is oral fluid testing and to some extent breath THC testing. Okay, so you're going to have this. You're going to see that the answers all load up one at a time. But the bottom line here is that in California and Washington, you can test for cannabis. You can still test for marijuana, but for pre-employment testing in Washington, you're going to want to go with oral fluid testing. In California, for both pre-employment and post-hire, like reasonable suspicion, random testing, et cetera, you're going to probably want to go with oral fluid testing again if you want to continue testing for marijuana. Now, this leads us to Ken's portion of the presentation, and I'm going to turn the microphone over to Ken, and I'm going to give you the rights to advance the slides, Ken. So it's in your hands now.
Great, thanks, Ben. Well, thanks everyone so far for the attention today. I wanted to dive in a little bit deeper on the technology that we've built that I think addresses a lot of these challenges and concerns related to how cannabis has been legalized and a lot of the complex laws that are in a lot of different parts of the country. So the product that we've built really, as I said, is intended to detect impairment as it is being experienced. And so whether or not someone consumes an edible or smokes cannabis, we're going to detect impairment as it is being experienced. And so that's a very powerful change from what has happened historically, where you're looking for the presence of a chemical in the body and trying to derive if there's been a policy violation as a result. With GAZE and with other, potentially with other impairment detection technology, you can actually find out if someone is currently experiencing impairment. The other thing that's really interesting about our technology that I wanted to note is that it is useful for a broad variety of substances. So it is not confined to cannabis. We actually have data for every class of substance, from alcohol, opiate stimulants, cannabis, and others. And our technology is able to detect impairment as it is being experienced from each of these. To date, we've done a cannabis clinical trial, which was the largest ever conducted in the world. And we're kind of halfway through an alcohol clinical trial. We've done our first iteration of that. We've got another iteration that is coming. We're going to continue doing other clinical trials on other substances of impairment and basically work our way all the way through each of these, doing both data capture and validation. This is, I think, the future of keeping a workplace safe in light of rapidly changing drug laws and rapidly changing substances of impairment. So the technology we've built is really based on the well-known and understood drug recognition expert eye tests. So these are tests that have been used by law enforcement for about 45 years. And what we've done is we've created an automated version that runs in a VR headset. So that's the image you see there on the right. The VR headset runs through each of the drug recognition expert eye tests precisely according to how they're intended to be done. And we capture both high precision eye movement data and video throughout the testing process. The data then gets analyzed using our machine learning and statistical algorithms to find the same indicators of impairment that law enforcement know to look for. And so you'll see in the middle there, we've got a mobile app, and that's basically the screen that you see after a test is conducted. And so what that is intended to show is you have put an individual through the test, they've shown various indicators of impairment, and there's probably a drug test that needs to happen in that case. Our test data all gets pushed up to the cloud where it is then stored and accessible by you. We also have, as I mentioned, test video, which is a very useful piece of corroborating evidence that is human interpretable. So in the case where you ever had someone challenge the assertion that they were impaired on the job, you can actually have an expert witness look at that video and say, yes, we see the signs of impairment that we would expect to see for whatever drug of impairment. And these, all sort of work together to create, what I believe is a really, really powerful tool for businesses to use in keeping the workplace safe. This slide is an example of the technology looking at, sort of different indicators. And this is an example of one of the indicators for depressant drugs and alcohol. It's called horizontal gaze nystagmus. And so what we're looking at here is the peaks and the valleys in this chart. On the left-hand side, you see the sober chart, and on the right is the impaired chart. Obviously, they're very different, but what we're looking for is a very characteristic waveform called nystagmus that is basically a jerking motion that the eyes make, or a bouncing motion that the eyes make on the periphery. So the peaks and valleys on the left are relatively smooth. On the right, we've got this characteristic waveform that we look for. So that's just an easy one for people to understand and see, which is why I put it up today. But we analyze over 120,000 data points in every single test that we conduct. As I mentioned, today we're effective at detecting an impairment from a broad variety of substances. And we're growing that all the time. We're also looking at combinations of substances so we can understand what impairment looks like if it's a combination rather than a single substance. We really believe that GAZE is the best fit solution for detecting active drug impairment. And it's a very easy solution to deploy. As was mentioned in the intro, we've got deployments across the United States. We also have units in Canada and New Zealand. And the product is really easy to deploy. We can train anyone to use it in about an hour. It's portable, so you don't need to be tethered to a computer or in an office or anything like that to conduct a test. You can take it out into a field or into a job site, into a mine even, conduct a test, and then as long as you can access Wi-Fi somehow, even via a mobile hotspot, you can get test results. It's non-invasive, or less invasive, I'll say, than a typical drug test. You're not capturing a bodily fluid. There's no DNA implications or anything else like that. And it's 50 state legal. There's no restrictions on how GAZE can be used today in the United States at all. Each test takes about 6 minutes to run. So that is from the time you press the start test button to the time you have test results is about 6 minutes. Depends a little bit on your upload and download speeds, but that's about what it takes our customers. And then with each test that we conduct, we also capture very detailed information about who conducted the test, on what device, using what version of our software, and then the geolocation as well. And with that, I will pass it back to Bill.
Okay, so one of the reasons why I thought this was a good topic to present and to combine on is that I think going forward, we're going to see employers looking for ways to do drug tests faster, more efficiently, maybe being able to do a lot more drug testing on site and combining it with some type of screening method that shows impairment specifically. When you talk about certain laws, Nevada, Colorado, certainly California, Washington, with their marijuana laws, they've not only legalized marijuana, and in those cases, we're talking about recreational use of marijuana, but they've also included language that starts to restrict what employers can do in terms of drug testing and in terms of what they can do with a positive drug test result. Now, I often use Illinois as an example of this, as an egregious example, but Illinois actually, to their credit, went in after they passed it and made some changes to it that's much more user supportive, employer supportive, I should say. I think going forward, we'll see a lot more focus on impairment identification through impairment screening services. In fact, let me go to this slide here. This year, I think we're going to see more of a move toward oral fluid testing, the new DOT regulations that will hopefully become usable before the end of this year, embrace oral fluid testing, lab-based oral fluid testing. In that case, I think we'll see a lot more rapid oral fluid testing because it's just so easy to do. I think we'll see a lot more proctored virtual testing. We got a whole presentation on that. That would be an entire webinar. But I think it'll be in combination with impairment screening. And that's what I love about the GAZE technology. So at Current Consulting Group, we get approached by lots of different startups with technology that sounds great. And it's always a matter of whether or not they're ever actually going to have a product. In the case of GAZE, the product, the instrument already exists. And as Ken mentioned, there are companies of all different sizes that are using it. And I think you'll see many companies looking to combine drug testing, especially recent use detection methods like oral fluid, with some type of impairment screening so that the two results together strengthen the legal defensibility of the employer's program to remove impaired workers from performing safety sensitive functions. I think that's really sort of the wave of the future. So those would be my predictions for this year and beyond. And with that, we've come to the end of the formal part of our presentation, but we would love to entertain your questions. So let me turn it back over to Jessica for questions. And you can continue to put questions in the chat section if they come to you and you'd like us to address them. And any questions we don't get to during the time that we have left, we'll email you afterwards with a response.
Thank you so much, Bill and Ken. So let's get started with some questions that we have. One question that was brought in today is, many employers are dropping THC testing. How easy is it to transition to testing with gaze? Probably be to you, Ken.
Yeah, I mean, it's really easy. So as I said, it takes about an hour for us to train anyone. It's a very easy product to deploy. We have a sample policy framework as well on our blog that I can send over to anyone who's interested. Typically the longest portion of the deployment of the gaze technology is getting that policy change implemented. It's not terribly complicated. As I said, we do have contractors we work with that do that work all the time, and happy to make intros to those people as well. You know, I think that the framework, though, really needs to be that gaze is not replacing a drug test. It is allowing an employer to detect impairment. Typically, our customers are then doing a confirmatory drug test in order to validate that there is an impairing substance in the employee's body. And that really creates the strongest possible body of evidence that can be in order for them to have confidence in taking a next step.
Okay, great. Thank you for that. How defensible is impairment detection technology like gaze?
I'll take that one as well, if that's okay. The reason that we utilize the drug recognition expert eye test is because they have been used by law enforcement officers for over 40 years and are recognized by courts as being accurate. There's a huge body of evidence behind them. So we believe that our technology is highly defensible. That has not yet been proven in court, I'll say. So that's a big caveat, but it is, I think we're set up for success in that area and as prepared as we can be for that eventuality.
Okay.
And let me add something, Jessica, that
Thank you.
one of the things we do at the Current Consulting Group is we monitor state drug testing laws and legislation. So our clients get updates every month on any kind of legislation that may be moving forward on drug testing. And we maintain a very extensive database called Current Compliance. You can find it online. We haven't found any states that would prohibit the use of the gaze technology. You're not necessarily going to look in a state drug testing law. You're going to look in other laws, but we haven't found any problems with the use of this technology in any state. Besides the research we've done, have you run into any states that it would be problematic?
No, you're correct. And we've had this validated by an outside law firm called Ogletree Deakins, which is one of the largest employment law firms in the country. So they've done that analysis as well, have come to the same conclusion, and that includes biometric security laws and HIPAA. So our product was designed from the ground up to be compliant with biometric security and HIPAA, and there's no laws that are currently on the books that would preclude using gaze in any of those states.
Great, thank you both. So then this is just me kind of following up on this. How would you then implement technology like this into your program? I know Bill's kind of our state law policy expert. How would someone start using a product like this? What would you recommend they do to be able to bring this in and have their policy reflect that? Bill?
Well, I would defer to Ken on this, sort of, Ken, like when a company comes to you and they say, yeah, I love this, I want to do this, what are the first steps they go through to implement this technology?
So typically what they do is an internal process of deciding what the new employee impairment and drug testing policy is going to look like. And that varies between a very short process of deciding it's going to slot in here, we're going to go forward very quickly, to some larger companies can have a somewhat protracted process of figuring out what they want their policy to look like going forward. We are happy to advise on that. As I said, we've got a sample policy on our website. We've also got contractors that we work with regularly that can do that advisory work for our customers. It's not as big of a lift as it sounds, though. We've never been blocked by a company that has wanted to deploy us for anything related to anything like that. And so it's not typically as big of a problem as it might sound on the first look. Again, the way our customers typically deploy it is as the first line of defense to prevent someone from being impaired in the workplace. If they do detect signs of impairment, they then move into a more traditional, usually an oral fluid drug test, to verify that an impairing substance is present. Some customers actually do it in reverse, and this is a common way that TPAs will use GAZE, is they'll do a drug test first, and then they'll do they'll do an oral fluid drug test first, and then they'll do GAZE second. So if they detect impairment, then they can, if they detect a drug, they can then validate whether or not impairment is being experienced.
Okay, that's very interesting, which kind of leads to a couple of questions that we had coming in about how GAZE can differentiate between impairment and maybe a medical condition or sleep deprivation, things like that, and how the system would react. Go ahead.
Sure. Excellent question. We get that one a lot. So each category of drug has a unique way in which it impacts eye movement. So for example, stimulants will make the pupils very large and react to light in a very particular way. There are also some other indicators of stimulant impairment that we're honing in on. Opiates, on the other hand, will make the pupils very small and they'll react to light in a different way. So each drug class has a unique biosignature, we call it, that presents in the eyes. So our system is picking up on those biosignatures. We're actually in the process of pulling together a clinical trial on fatigue that'll happen hopefully late this year, and that's going to be in partnership with a major university that studies fatigue. So that'll be a really interesting one for detection of fatigue, but our system does not currently detect the signs of fatigue as impairment, so we've never had a problem with that.
Okay, excellent. That's very interesting as well. Fascinating stuff. You think like when you go to the eye doctor, they're just checking it out, but there's so much that you're gathering from there. That's fascinating. Another question is, would you use a GAZE system as a replacement for drug testing?
Not typically. That's a company decision, but so far our customers have, I believe, universally chosen to retain drug tests, usually again as a confirmatory step if they detect signs of impairment. We would suggest that remains the policy, because you're capturing additional data that I think is really important as you consider whether or not you're going to take adverse employment action against someone.
Right, excellent. Okay, wonderful. Thank you so much, Ken. Thank you, Bill. We are coming up to the top of the hour, so I just wanted to give Bill and Ken an opportunity if you have any closing remarks or any other questions you wanted to bring up to each other. Otherwise, we will start our sign off. Bill, Ken, anything else for us today?
I would just say thank you to everyone for attending, and I would love to answer any additional questions. My email is ken@gaze.ai, so very easy. And yeah, I'd love to hear from anyone, and happy to chat about how this gets deployed or what that looks like with anyone as well.
Yeah, and the only thing I would add is I just think we're going to hear a lot more about this type of technology. It's the wave of the future. I think we're just going to see a lot more employers looking for alternatives to help them continue to screen employees for drugs, particularly marijuana, while at the same time being able to show that somebody's actually impaired.
Yeah, Bill, if I can pile on really quickly, one of the, I think, most interesting use cases for our technology is allowing for employees to safely utilize cannabis on their personal time and then still demonstrate that they're, able and ready to work when they arrive at work. And that's usually what our customers end up honing in on is, often they're in a cannabis legal state and they want to find a way that their employees can, utilize a now legal substance, and so they can retain those employees and not be firing people unnecessarily, which is of course extremely expensive. And GAZE really facilitates that.
That's excellent. Yep. Great information, great presentation by both Bill and Ken. Thank you both for your expertise and your guidance in there. I know for me, this has been a very educational webinar. On behalf of Current Consulting Group, we'd like to thank you for attending today's webinar. And also on behalf of GAZE, we'd like to thank GAZE for sponsoring today's webinar. We hope that you have all found today's presentation informative and helpful. This presentation was recorded and you will receive information on how to access that recording via email. Also, if you had submitted a question that wasn't answered, we will answer that offline. And also, if you have other questions, as Ken mentioned, his email is ken@gaze.ai, or we also have contact information on the screen right now if that's better for you. And last, this presentation did qualify for continuing education in addition to being so educational and informative. So if you're interested in the continuing education credits and you've been with us for the full hour, we will send you over those codes in the email with the link to the recording. And with that, that concludes today's webinar presentation. Have a wonderful